Hi, I'm Sammy. I work in Alta's legal department. I'm a legal specialist. What that means is, for the most part, I oversee the agency's conservatorship review process, and then kind of work with the courts, and then they do a few other miscellaneous things. And for those of you, actually, let's do a quick survey, show of hands. How many people know about conservatorships? Know what a conservatorship is? 1, 2, 3, 4, 5. Okay, so we'll talk about that down the road, but primarily the chief purpose of today's workshop is at least to clarify the rights of regional center clients as adults and how to know is best to support the client as they are in that transition age. So actually, can I get a show of hands again? How many people here are related to a client or a parent? Okay, most parents. Okay, so let's begin. Let's get started. So this is just a basic overview of what I just said a second ago, but we're going to provide an overview of supports and services and kind of go over the planning process and what it means when a client becomes 18. So for children under 18, everybody has rights. And they differentiate. So when you're under 18 and you're a minor, you have some basic things, some things that you can get. So for example, food, clothing, shelter, to have your wishes considered, health care, to participate in programs, obviously to go to school. And those rights, for the most part, are usually only for children, and they don't translate always to when someone becomes 18. So on the next slide, we talked about how some differ. So when you turn 18, most of the rights that you previously had can dissipate, and then these rights, which are somewhat more significant, like voting and participating in the democratic process, joining the military, being able to work, practice a religion, file a lawsuit, sometimes drive a car, and a lot of your rights and responsibilities increase when you reach a certain age. And it's important to note that for a lot of our clients, these rights are the same. So everybody maintains these rights, and they don't necessarily change just because of someone's developmental disability or any disability for that matter. Any questions so far? Okay, next slide. And this comes from the Lanterman Act. The Lanterman Act is a piece of legislation, and it's primarily designed to govern the regional centers, and it says what the regional centers are supposed to do, how they're supposed to do it, what clients get, what regional centers get, and kind of lays out this massive statutory scheme. And part of the Lanterman Act, right from the beginning, it spells out that regional center clients have the same rights and responsibilities guaranteed by all other individuals in the United States, a right to services and supports in the least restrictive environment, and then obviously the right to make choices. And those don't change just because someone's a client, and I think that's why it's explicitly spelled out in the law from the start. So, next slide. When someone turns 18, irrespective of whatever disability they may have, there's always a rebuttable presumption that they have capacity. So a lot of people sometimes have a difficult time, for example, grappling with a client being able to consent to a medical treatment or signing a contract. And they say, oh, well, this person doesn't necessarily have capacity, or I don't think they can understand what they're signing. But until some court finds by some clear and convincing evidence that this person doesn't have capacity, in almost all situations, someone has capacity to sign things. I think that definitely changes. In other countries, it's a little bit different. I know, for example, and I know we have a lot of clients sometimes that may come overseas and will say that this is just crazy because where I'm from, this is not the case at all. But in the U.S., at least under the statutory law in California, you maintain, you will have the presumption that you have capacity until a court says otherwise. And we'll talk about that down the road, about what that means when a court says you don't have capacity. All right. Any questions? Yes. Yeah.
Legal capacity, what does it really entail? How do you know? Because I have a special needs child who has developmental delay, as in cannot, well, speaks, but like very basic words. Her
Yeah.
name, let's go, that's it. It's not a, yes, mom, I understand this, or ask questions, so she can't speak sign language or anything like that. And
Yeah.
can't get her to repeat or anything like that. So with that, how would I know, or anybody know, that she can have capacity to do and understand something when she can't relate that information?
Yeah, no, that's a great question. And I think it's kind of twofold. So the first part is what is capacity, and it's an ability to understand what's being said to you and trying to retain whatever's being said and articulate some response. And for example, in your daughter's case, even though she may not understand, and you might, agree with that kind of assessment, she technically still has capacity until the court says otherwise. So when you get conservatorship, then there's some determination that someone doesn't have capacity. And that's partially a safeguard, because otherwise then anyone can claim someone else doesn't have capacity when they do things. So, if I'm having a bad day and I go buy a phone and can't afford it now anymore, I can say, I didn't have capacity when I did that. So it's partially to protect certain people, but it's also, for example, when I do something like that, it's obviously to protect companies, but also in the past, and part of the Lanterman Act was this idea that clients have rights. And with that, until there's some finding otherwise, they maintain that right. Because a lot of the time in the past, people said that person didn't have capacity, and that was kind of the status quo, if that makes sense. Does that answer your question? And we'll talk about it in the
But I'll
next
have further questions.
We'll talk about it in the next slides about how you can make some determination about capacity, but then it gets kind of tricky. I get what you're saying.
But Sammy, they
Yeah.
are presumed to have, the presumption is they're legally able to make decisions unless the court says.
Correct. So there's always a presumption, irrespective of someone's
That's why we're
severity or
having a
level
meeting.
of their disability.
Okay, I'll have some additional questions.
Okay.
So then that means I have to act quickly, basically, for certain things, so.
Potentially. Yeah.
Okay.
All right. So adults, I think this is what we said, but just in a nutshell, adults with developmental disabilities, regional center clients retain their rights to make decisions unless removed by a court. So, next slide. So, part of kind of the considerations or factors when you're trying to decide how you can support someone in making decisions is first a client's understanding and consent, if they can understand what's being presented to them, and then if they can obviously understand it. And then obviously something that's really important is needs-based rather than automatic. So some people say, I think that X would be very helpful, but is it necessarily needed? So you're trying to assess in all of these options, and as we go further into the presentation or the workshop, there's options, and you're supposed to try to take all those options on this bandwidth from 1 to 10 and then see what does my child or what does this client need on the scale to meet their needs or their level of functioning. And then least restrictive option, and this phrase or the term least restrictive, it comes up a lot in the law in both conservatorships, the regional centers, and anything really to do with individuals with developmental disabilities, because it's intended to ensure that it reflects the attitude of the legislature, which is, people have rights. And then promoting independence and self-sufficiency, and that's kind of the purpose of regional centers. And then flexibility, accountability, cost. Because, for example, if you want to go through some court process, it might cost you anywhere from a few $100s to a few $1,000s. Whereas, for example, there are some other alternatives which may be no cost at all. And for some people, that might be important to consider. All right. So the first thing that we I want to talk about are these legal options for finances. So most of our clients receive SSI, which is Supplemental Security Income. And when they get that through the government, usually I'd say it's like $700 to $800. I'm looking at Jose. I want to say $700, maybe $900. You can have a representative payee, so that's a person that manages that money and then decides how it's spent, disperses it, gives it to the client if they want to give some of it in cash. But they make most decisions, and there is no rigorous or extensive process to become a representative payee. And most of our clients usually have a payee, and it can be a family member, it can be a friend. Alta has vendors that can also do that. And another option is ILS services or SLS services. And this is independent living services or supported living services. And some of our clients will use some of these services to learn how to budget. So you can go grocery shopping, for example, with an ILS or SLS worker, and they'll tell you, you have $40 and you need to go grocery shopping at this store, and you also need to go buy a t-shirt for tomorrow, and that's going to be $10. And they might help you understand how to budget for your money if you have a limited amount, for example. And then CalAble accounts. Is anyone familiar with CalAble? Show of hands? Kind of? Okay. So if you have SSI, after you have $2,000, if you save $2,000 or someone gave you, theoretically speaking, $2,000 cash, you'd be a lucky person. But in addition to that, you would no longer qualify for certain benefits because of SSI, or your SSI might be reduced because you are technically determined oversourced. So recently, California just enacted this, and it's called a CalAble account. So you can store up to, I want to say $15,000 in an account, and it can be spent on qualified disability expenses. So for example, rent, medicine, clothes. It's relatively broad, but it's intended to kind of shelter your public benefits, and it takes no more than like 5-10 minutes for you to enroll in that program or enroll in the account. But it's kind of like a bank account. But the only difference or distinctions is there's a maximum limit, or there's an annual limit of $50,000. So for some clients, if they are making more money or if someone wants to give them more money, that is a string. In addition, if you want to, for example, put more money, you would have to consider like a special needs trust, or you have to reduce your Social Security benefits. But the good thing about a CalAble account is that you can put up to $529,000 in it in California. So if you have a child with developmental disability, you could start this right now for them, and then just start depositing money into it. And then when they become 18, or if they are 18, then they can start using it, and it won't affect their SSI. Or when they turn 18, they can have like a credit card, a debit card technically, and use it, and it's not going to affect their SSI, so long as it's on qualified disability expenses. So this has been something that's been long awaited for a lot of our clients, because previously there wasn't a mechanism for them to have more than $2,000. Did I see a hand? Yes. Or another hand. I will get back to you. Yeah.
Can you clarify the limits or the maximum? You said 15,000, but then you said in California.
So 15,000. No, in California it's 15,000 across the U.S.
Okay.
It's 15,000. If you have a job, you can put up to an additional 12,000 if you have a job, and it's below the annual salary is below or less than the poverty limit, or the national poverty average. So you can put up to 12,000. So technically, I know we just supported a client opening a CalAble account, and she was making $10,000 at her job, and then she also had $15,000. So now she's going to be able to put in $25,000 into the account because of her job. And then you can put up, in a lifetime, you can put up to $529,000. Yes.
Say that again, how much?
$529,000.
So if you have a job, it's 15 plus 12 annually?
Yes. Up to 12, so some clients might make that, yeah, but yeah.
So
Yeah,
this is yearly, you're saying, the 15 and the 12?
Correct.
And then after some, if you get up to the 500?
yes. Mm.
So if they have 15, if they have this much in like interest that's accumulating,
Mhm.
and then they go over,
That's not a problem, but we're just talking about direct deposits.
oh, so it's only the direct deposit?
Yes, you can deposit no more than 15,000.
So special needs trust is something that needs to be considered like further down the road?
No, we're gonna talk about that in a second.
Okay.
Yeah. I like that you're ahead of the game.
So is there an age minimum for the CalAble account?
I don't believe so, but I can double check. But
Okay.
I have been to a few of their trainings, and I don't think so. My card's in the back, so you can grab it, and I can email you. We have a packet that we send out about CalAble, and I can send that to you in the mail. And it has all the information. But I don't think there is. So then there's a financial power of attorney. And this is similar to a conservatorship in that it assigns another person certain rights for you, or decision-making ability. So they can sign, for example, a contract for you, they can go to the bank, access certain documents, a hospital, for example. Sometimes they can be used also to make financial decisions. Most of our clients don't have a substantial estate or a lot of money or assets, so with that, it's not necessarily that helpful. And then a special needs trust. So the two things between a special needs trust and a CalAble account is that a special needs trust that has no limit, so it can be millions of dollars. We have clients with homes in special needs trusts and multi-million-dollar special needs trusts. A special needs trust, oh, actually, we will talk about that in the next slide, all about special needs trusts. So I'm not going to say too much, but I will get back to it. Please go next. So financial power of attorney, you just appoint an individual, I briefly touched on this, to handle financial matters. There are standard forms, it's free. So for example, when we talk about conservatorships, it might cost you money, but sometimes people find that the power of attorney isn't just as effective. We'll talk about kind of the shortcomings of that down the road in the next slide. So special needs trust. So it permits you or to start a disabled person to maintain eligibility, which is similar to a CalAble account. You can put in real property such as a home, a car, and cash, stocks into a special needs trust. And then they can pay for any item not available that would not be covered through SSI, for example, or any other public benefit. So a special needs trust has no limit to it, but the downfall is that it requires usually an attorney to set it up. So it's like a document. It can be anywhere from like 10 pages to maybe 50 pages, and there are different people in a trust. So for example, there's a beneficiary, there's a trustee, there's an executor. So it is kind of legalistic, which is why it requires an attorney in most cases to help you, because it can be confusing. And then, for example, if the trustee, which is the person that manages the trust, like passes away, in some instances it would require you put the trust into probate and take it to court, and then have someone appointed as successor trustee, and it can be a little confusing. And then sometimes people will get into disputes about special needs trusts, about how they're spent or what someone's doing, and you can also go to court with that, and you can litigate whatever's happening. So if, for example, someone has like $5,000, personally I wouldn't think that it's worth it to go through a special needs trust, because it might cost a few $1,000s to set it up. So realistically, you're only going to have $1,000 left. But for example, if you have $500,000, a special needs trust would be more helpful because, for example, we have some clients whose parents left them $1 million in a special needs trust, and when they passed away, there wasn't really anyone to support them, and then there might have been someone that could potentially influence them or try to, or another family member who suddenly wants to gain access to that money. So this one, special needs trust, is helpful because in most cases there's oversight, there's accountings that you're supposed to file with the court. People review what you're doing. If someone thinks that something that's happening is suspicious, some action or investigative body can oversee it. So for large assets, I would think that a special needs trust is better. That's what I would do, at least if I was a parent and I had a large sum of money, because I feel that it's a lot more safe and there are a lot more people looking into it. Whereas with a CalAble account, realistically, it's kind of like a bank account. And with bank accounts, there isn't much oversight when it's just like a debit card, for example. Does that answer Deborah's question, I think, about special needs trusts? Okay. And then if you ever do want to set up a special needs trust, Sacramento County Superior Court has a list of attorneys that they recommend for certain things, and I would also recommend to use that list, and my card's back there. So if anyone wants a copy of it and is considered a trust, I would say those are some more experienced, credentialed, and trustworthy people. And then next slide.
Excuse me.
Yeah.
She's saying real property, man. I just met with a gentleman today who he purchased a condo while he was making really good money. He's disabled. Eventually had to quit the job because of medical conditions, but lost his Social Security because he owned property. He tried gifting it to family, and they said, well, the equity in the home, you could have made $50,000 in equity, therefore you could have lived off of that, so for the next 3 years, you will not get SSI. could he have created or can he still create a special needs trust for that real property?
I'm not wholly
That's-
familiar.
Yeah, this is like way out of my wheelhouse, so.
But generally speaking, we do have clients that do have special needs trusts that their home is in, and they.
Okay,
still get
I'm
that
gonna
list.
refer them to, I'm
Yeah,
gonna get your card, give it to him,
yeah.
I'll get that list, so thank you.
Yeah. Possibility. Any other questions? Okay. And then the next option, which is a conservatorship of the estate, and we're going to talk about conservatorship more in depth down the road. But conservatorship of the estate is usually just having assets that are in shelters in a special needs trust or just a CalAble account. It's just like having a Wells Fargo account or owning property. And a conservatorship of the estate is when a court appoints someone, sometimes a family member or a professional, to manage, marshal the assets, marshal the estate, and then make decisions with disbursements, how it gets sold. And this is usually for clients with a lot of money in investments or homes or businesses, or their family has left them some amount of money and they need it to be marshaled or located, for example. All right, any other questions? So when it comes, now we're kind of done with the financial portion. We're talking about personal decision or person-centered decision making. And there are several options, some of which are the planning team, and I think that is the hallmark of the regional center, and how services and supports are crafted, especially effectively. And then there is assignment of educational decision-making rights, power of attorney, conservatorship of a person, and we'll go over all of those in depth. Next slide. So the regional center planning team, or a planning team in general, is the group of people. Usually it consists of a client, whenever appropriate. If that's a minor, for example, they're a parent. If they're under a conservatorship, they're a conservator. And then a service coordinator or a representative. They can also be a service coordinator and sometimes a supervisor or anyone else from the regional center. And then sometimes service providers like a day program, or if someone is living, for example, in a group home staff. And what these group of advisors in fact do is create a plan as to how to make someone the most successful they can be at whatever they want to do. So some people have objectives like, I just want to be healthy. Some people have objectives that they want to be a movie star. So it really depends on what people want to do, and then based on whatever those aims are, then we try to find supports and services and contract with vendors to make that possible. So you're kind of supposed to serve in a capacity where you're making someone or helping a client towards whatever goals they may have. Any questions? Okay. An assignment of educational decision-making rights is primarily helpful in the IEP process. So after someone graduates, or not graduates, but once they turn 18 to 21 or 22 and you're in the educational system or the public education system, there is a basic form. It is just one page where a client can sign and it authorizes whomever it may be, usually a parent, to make decisions and participate in the IEP process. I would say that in our experience, most school districts don't really offer it or advertise it, and at least anecdotally in my experience, but it is a free form and it allows you or empowers you to make decisions on a client's behalf. And it can usually be found online. And this, a lot of parents find helpful because sometimes they're concerned at 18 the school district might have one view and the parent might have an opposing view, and sometimes it's partially difficult to reconcile the two. Yes.
So for a higher functioning client, this is only if they're still in that high school system within the school district, or does it apply to college too? Because I thought colleges didn't use IEPs.
No, colleges don't use IEPs, so for someone in college that would not be applicable, but it's anyone that's still in the IEP process or in high school, or in a high school program.
They have IEPs there, correct?
I believe so. I'm looking at Jose.
That's a transition program.
So that's different.
Yeah, you can utilize this kind of document.
So as long as someone's 18 to 21 and the client consents to it, you can make the decisions, sign IEP, and authorize services and discuss with school professionals. And you can look up, there's this code section, if you look it up, it usually leads you to the form. Or you can actually look up the terms themselves, the assignment of educational decision-making authority, and find that online. If you have trouble also, again, my card's in the back, and then our contact information is at the end of the slideshow, and then email, we can email you the PDF.
So
Yes.
after 21, it would be considered the court assigning his the capacity.
So at 22, it depends on what a client wants to do. So some clients, for example, might want to go to a day program, and that would be part of the regional center planning team process, so the IPP team and the planning team can reach that kind of decision. And usually after 22, I'd say the planning team is vital because you can all get together. At the regional center, we have different like specialty groups or specialty departments. So I've gone, for example, to a planning team before where a client was having a particular issue with like a bank, or sometimes we have like a forensics or criminal department, and they can come to an IPP meeting and help you or work through the problems, and you're supposed to kind of bring like the best and the brightest, put them together, and then see what kind of solutions we can create. Does that make sense? Okay. And a healthcare power of attorney or advanced directive, it's similar to a financial power of attorney, but it is just a form. Sometimes it can be a few pages, and a client signs. And there is no, for example, test about capacity, but you can sign it and assign someone else to make decisions for you with a medical provider. It doesn't necessarily replace the client's decision-making ability. The client can also make decisions, but it also allows another individual or extends that authority to another person. Sometimes, or at least one of the better things about it, I would say, is that it is low cost, it's free, it's online. There are some of them that you can have just with 2 witnesses to sign it, and it can be certified. Other times you might have to go to a notary, but it's relatively straightforward, and it can take just a few minutes to establish. The downside about power of attorney is that not all doctors or dentists will accept it. So there are, I'd say, maybe a handful of cases that I just hear about where a doctor does not want to or doesn't feel comfortable accepting a power of attorney because they don't feel that a client should be able to sign that, or they don't necessarily think that it is legally sufficient to authorize medical treatment. So that sometimes does happen. So we sometimes recommend, if someone's considering alternatives to conservatorship, to sometimes try this, because sometimes it's very effective and you don't need to do anything else, but other times you might need to take another option. The regional center medical consent. So for example, we have run into cases where a client needs a certain medical treatment or surgery or procedure, and the medical provider or the doctor does not want to accept whatever consent the parent or the client has, or we can't find, for example, a parent or a family member to authorize. And the law provides regional centers the ability to consent to certain treatments when we can't reach, for example, a conservator, when someone doesn't have any other family members, and we'll try to do at least some robust search for anyone else in the client's life that may be able to assist in making the decision. But it's not a blank consent, so it's not like once we sign once, we'll authorize everything. It's usually for an individualized treatment or procedure. And I will say that this isn't something that we casually do, or we do loosely. It's a very rigorous process, and it involves usually a service coordinator sending it to our clinical team, and then there's a staff physician. The staff physician will usually communicate with the other physician and then discuss it, and then sometimes the legal department gets involved, and then it goes back to the service coordinator, and we try to find anyone else that's involved in the client's life. So it's not something that's done in a hasty manner. I will say that. Any other questions? Okay. Written consent to records. So for example, when we talk about alternatives to conservatorship or other options that you might have, you can use a consent form. The regional center, for example, has a consent form that a client can sign authorizing any individual that they would like to access their records or obtain copies of records. We usually go over the releases or a consent to access records at an IPP, for example, and it has to be HIPAA compliant. It allows you to be present at, for example, regional center meetings, or to call a service coordinator and ask them questions or obtain information from them. Medical providers and hospitals also use HIPAA forms. They usually have their own form at the hospital. I know, for example, Kaiser or UC Davis has a form, and a client can sign that and authorize someone else to access their information without them always being there or doing it themselves directly. And sometimes that's also helpful. All right, next question, or next slide. So supported decision making is a form that sometimes some families prefer to use, or sometimes clients prefer to use, that allows individuals with disabilities to retain decision making abilities, but they also give or identify certain people that they want to help them with those decisions. And it's kind of like a written agreement that you can also find online. And it says, hey, when I'm making X decision or when I'm making Y decision, I want this person to be involved. And some clients like to do that instead because to some extent it is less restrictive, but it also allows for a more meaningful and interactive dialogue between everybody because you identify certain point people.
So where do you find those forms?
That would be online, but if you want to email me any of the forms that you want today or any of the forms that we talked about today, we can bring them, or I can email them to you or mail them to your home.
But you would just look up under supported decision
Yeah,
making,
supported decision
and they're
making.
just blanket forms.
Yeah. So conservatorship, that is the big one. So a lot of these alternatives, when we talk about restrictiveness or kind of intensity, all the other forms or all the other options that we talked about, they were kind of between a 1 and a 6. I would say on terms of restrictiveness, and a conservatorship was really like 7 or 8. It's because a court says that this person doesn't have this right anymore, and then they're ceding it to someone else to make. And it's a lengthy process, and it requires a lot of scrutiny because it is relatively significant when you take someone else's right away to do something. And it's kind of the primary goal of conservatorship is to ensure people's needs are met, and somehow through a conservatorship to kind of make that more formal, that authority, and to allow you to do that more in a more centralized fashion. Yes.
So would you say that conservatorship for a child, an individual that, like I said, it's very difficult. I'll talk to you afterwards, but
Yeah.
nonverbal, has no sense of security, cannot write her name, just, so basically she has some capacity, but there's no way of knowing how much capacity that she can make a legal decision to say, yeah, do the surgery for me. As it is, I say, let's go, and she'll, stand up, but I'm doing things to help her stand up, and she goes.
Yeah.
So for an HIV test, a pap smear, or any medical decisions or a surgery, if she can't communicate, short from screaming and crawling out,
Yeah.
what would be the better protection for her, the conservatorship versus everything else, or,
I would say that's difficult somewhat to answer, and we can talk about it afterwards, it is case by case, but I know that some families that have, for example, a client who's in a similar situation have never had a conservatorship and found it to be just as effective, and they can navigate most areas of their life. But we also have clients that I've also seen that have tried all these alternatives, have gone through the types of conservatorship, and didn't find that anything was successful until they got a conservatorship, and that was really one thing for more successful. So it kind of depends on what works. But anyways. So the next slide. So there's 3 types of conservatorship in California. The first of which is a limited conservatorship, and it's designed specifically for regional center clients. No one else could be conserved through a limited conservatorship if they don't have developmental disability. And then there's a general conservatorship, which is designed for protection of usually the elderly or people with dementia. It's usually designed for people that have no decision-making ability. Not even basic decisions, and it's one of the more restrictive types of conservatorship. And then finally, there is an LPS conservatorship, which is a grave or serious mental disability. At least in my experience and in my supervisor's experience, we've seen like a handful of them among the thousands of regional center clients, because it usually has to do more with mental health. So what a conservatorship can do is allow you to access certain services, and that's how we tend to frame it. It is a vehicle to access a certain thing. So sometimes that might mean, choosing a residence, healthcare, communicating with professionals. Sometimes it can be housekeeping, transportation, a day program when someone turns 22, and agreeing or consenting to the provision of certain services. So it is helpful in that sense, in that you're kind of coordinating and serving as like a liaison on behalf of a client, and you have this like formalized legal authority to do that. It can potentially protect clients from legal consequences. So and when we say potentially, that's because we have some clients that are very savvy and sophisticated, and sometimes a parent might seek conservatorship to help them or stop them from doing X. But sometimes, when they're at Verizon and they see the new iPhone Max, they want the iPhone Max, they are going to sign for the iPhone Max and then come back and surprise their family. It's usually somewhat of a pleasant surprise, so it depends. But sometimes a conservatorship can't necessarily stop you from doing something. And that is a key takeaway, is that there's really no database about conservatorship. There's no central place. So if you have a conservatorship over someone's right to marry, they can still go to the courthouse and get married and come home and surprise you. It'll be a fun surprise, but either way, conservatorship may not be able to actually stop that. It would be more helpful from a reactive standpoint, where you can try to go seek a divorce or an annulment. But it's not centralized, or that information isn't readily available to everyone. So when someone goes and signs something or tries to get married, there's no like background search or something. Yes?
So my daughter's 17, she'll be turning 18. She
Yeah.
lives at home. I don't see her living somewhere else anytime soon. Is a conservatorship absolutely necessary to function after they're 18? I guess is my question. As her parent, I realize she has her own rights when she turns 18.
Yeah.
But we're still basically monitoring her day to day, and I guess I'm really trying to figure out, is a conservatorship absolutely necessary because they have their own potential decision making once they turn 18, or is it something's necessary, it may be a conservatorship or something else? But I guess what I keep hearing, or what I keep, in the groups and stuff that I'm in, is that when they turn 18, because it's automatically assumed, they have the capacity to make decision making. If you want to do anything, whether it's take them to get signed up for SSI if they don't already have it, make a medical appointment for them. Because they're 18, all of that goes away for you as the parent, because they think they can do it on their own. So then you have to have something to do that. So I heard you say some families don't have conservatorship. So how do they navigate through that? How do they make those appointments and sign up for SSI and do all that when they turn 18 if it's automatically assumed they have the ability to do so?
Well, I can say, for example, we have some clients that had the same doctors for most of their life, and they've known this family. So sometimes the doctor's not going to be like, oh, I need a conservatorship to treat this person. So sometimes you have established relationships with various people in the client's life already, and they don't need some formalized legal authority for you to assist in making decisions. The second thing is that if some clients are able to consent or articulate that they want you there, that doesn't necessarily preclude you from participating or supporting the client. I know if I went to a medical doctor and I wanted my mom to come in with me, and I said, oh, I want my mom to come in with me, my doctor's not going to say, oh, your mom can't come in, because technically you're the patient, and the doctor's supposed to kind of follow whatever you like. So there is no law barring someone from coming into an appointment if a client consents or if a client wants you there. So part of it is about a client's willingness or desire to have someone else participate in their life. And that's kind of the difference between the alternatives and conservatorship. Whereas the alternatives, if a client wants you to do something or invites you to participate or signs a power of attorney, for example, you are able to do certain things. So at 18, it's not like you can go to the SSI office with the client. If you take the client and you're like, I want to sign my daughter or sign up for SSI, in most cases, SSI will allow that from what I've seen. And this is kind of limited to my experience and what I've heard, but it's not like they're not going to talk to you whatsoever. They're not going to assist the client. They're not going to support them just because they're not under conservatorship. Conservatorship is not somehow dispositive, or it's not required to do everything. Okay. But that is peddled around the law sometimes, where you need a conservatorship to do everything. But that's not necessarily the case. There is no law that says if you don't have conservatorship, you won't be able to access services.
Okay, so let's say I do a conservatorship.
Yeah.
And down the road, she decides she wants to do an independent living type situation with peers or, you know, in a house or whatever. And she's able at that point to, she's grown up more, she's more
Yeah.
mature, she's able to make those decisions. Can the conservatorship then go away?
Yeah, yeah, and I mean, technically, someone can still live in independent living and be under a conservatorship. So it's not like the two are intrinsically like inherent or required. So we have clients, for example, that live on their own in a community in like Davis, and I know a conservator that lives in like Boston, and they don't live together. But sometimes if there are decisions that need to be made or questions, you can call a conservator in Boston and say, hey, does X need to happen or does Y need to happen?
Got it. Thank you.
Yeah. You have a question?
Yes. I'm a little confused.
Yeah.
Now, you're saying if they have some capacity, they can make decisions. Now, if they sign for something but they hadn't really read it and they're concerned, is that a legal document because they signed it?
That is kind of, it's difficult to say because some conservators have successfully, had a client sign something and then went to the bank or went to the store and said, oh, they are not supposed to sign this. They couldn't, they're under a conservatorship, and that person took it back and said, oh, never mind. But I know I was trying to support a family in Grass Valley where the client, I think, took out a loan for $10,000. And she was under a conservatorship, and the bank said, you've taken out the money, we're not going to do anything further, it's your responsibility now, or it's the client's responsibility, whatever happens, happens. So it's not always guaranteed with a conservatorship X is going to happen. So sometimes some conservators find it very successful, other times they don't. And not everyone understands conservatorship. Sometimes people, it's the first time they've heard the word conservatorship. So that is part of the problem, and that a client can still do things, there is no contract. I mean, there is no database or anything.
Yeah, I talked to a lawyer, we're going through it, but they gave me the impression that, concerns about documents and handling money, we had the conservatorship, then, she shouldn't be able to sign things and it should be legal.
That's the ideal world. And that's if everything worked the way we wanted it to be. That's how it's supposed to be, but not all banks or businesses will comply with that. And sometimes you might have to hire an attorney to go back to the bank and argue with them and say that this contract is null and void under whatever law. So it doesn't always work. You can't call them and say,
That's kind of weird, this is expensive, we're spending a lot of money for the conservatorship, and if it's not gonna be worth it, it's too late now though, because I've already paid in the contract. But I wish I had known this before I started.
And it's not always guaranteed, and we'll talk about how you can pursue conservatorship, about what ways you can. There are low-cost alternatives. Because some attorneys will charge a few thousand.
And I'm paying quite a bit. Those I've already paid, most of it.
Afterwards. So it's not always guaranteed, and that's part of the problem. But sometimes it can be helpful. So some people sometimes try to get, for example, the contract's power, and will say sometimes this might help me. I mean, sometimes it does, but sometimes it doesn't. And I think it goes back to the first point that it allows you to access a service. So you can go to Verizon and sign something for a client, or you can go and enter a lease for them or something and sign that. That would be more helpful, but sometimes taking it back is not as easy as it is accessing it. And then potentially prevent fraud, abuse, and neglect. Sometimes conservatorships can be helpful. If a client is in a bad situation, you can get them out. For example, you can call law enforcement, protective services, sometimes try to persuade them or convince them to not do something. But part of the problem is with conservatorship, there is no conservatorship police. So once you go through the conservatorship process, you're just given 3 pieces of paper and good luck, and then you see what you can do with it. So for example, I was at a family's home a few weeks ago, and they were talking about conservatorship, and they said, oh, well, what if my son goes on a plane with someone? I could show this to the TSA, and they would tell them to get off the plane. And I was like, that's not how it works at all. The TSA is probably going to say, what's a conservatorship? I've never heard of that. And then they're going to say, I don't know what that means. He's off the plane, they just landed, or they just boarded. So there is no enforcement mechanism with a conservatorship. It's just 3 pieces of paper with a signature at the end of the day. And sometimes if a client wants to do something, just like anyone else who wants to do something, they are bound to do it. Yes.
Just as a program director for a day program, know that on our end, before we bring someone in to attend our program, the regional centers provided us with that IPP. And even though you're right, there's no database there. I've never seen an IPP from Alta that didn't say they're conservative. Now I have to ask for that paperwork, so I have it on file. But it's a huge help for us in the day program to know that we have someone we need to work with in making decisions based on the program. So yeah, you're right, no database, but Alta at least communicates it to all the services and
Yeah, to all the
support
service providers and our vendors. Everybody always gets some report or either a packet or the IPP, and there's always going to be a legal status in there that says whether or not someone's under a conservatorship, and they'll look at that. But sometimes, for example, if we're talking about a bank or we're talking about like the clerk for marriage, they wouldn't have an IPP. So
Yeah, so the support, I just don't want you feeling like, oh man, I wasted money. The support services out there, the regional center and all of us that work for them and with the regional center, we're going to know. So on a day-to-day basis outside of this one-off, you're going to be okay. Yeah, and I thank the regional center for giving us that information. So.
yeah. And in most cases, when it comes to regional center services, conservatorship does make you kind of a primary contact person, and you, the service coordinator, usually reaches out to you first, tries to coordinate appointments and authorize services, because then you have to sign the IPP when you become conservator, whereas previously a client signs their own IPP. Yeah. So what a conservatorship cannot do, and we kind of touched on these, control behavior. Sometimes if a client is engaging in a certain activity that a conservator may not like or a parent may not like, they'll try to seek conservatorship, and it's not that helpful in those cases. Restrict movement. So with a conservatorship, you can't necessarily touch someone or tell them where they can or cannot go, so you can't like close the door and say you're not going to leave here. It's not that restrictive, and it wouldn't allow you to do that. So someone can always walk out or do whatever they like. They still have freedom of movement. Forced participation in activities against one's will. So sometimes a conservator might try to get a client to do a certain activity and they don't want to, and they try to hope that a conservatorship will facilitate that, and doesn't always. Deny access to services, and that's kind of what we said, a conservatorship is really more to access certain services or be the person that kind of facilitates all of those, but it doesn't always, or it doesn't allow you to deny services. And then isolate someone from others or medicate someone against their will. It's not that restrictive, or place someone in a locked facility. And that would be either through, for example, like a 6500 arrangement, which is a completely separate animal, or like an LPS conservatorship, which is for people with serious mental health issues. Any questions? Yeah.
So if you're in a situation like with an 18-year-old where you think that they may mature a little, and I have a 15-year-old and he is maturing in a lot of different ways that we didn't think we would see. Let's say you want to wait, you're at 18, they're going to live home for a little, foreseeable future. How long does a conservatorship take to process if you do find as a parent that you're not able to be as involved, with your kind of delayed young adult as you need to be, and that you do have to kind of want to insert yourself in the equation a little more? You say, hey,
that's what I'm saying. There's a certain,
you wait 18, you don't get a conservatorship, you see how it goes, they're living home, and by 19 or 20, you say, I think I need this to access a lot of things with them. How long a process does that take?
So the process always remains the same. It doesn't, and there is no timeline, or there is no end date for conservatorship. So we have a client that might have been just getting conservated at 46, and we also have clients that get conservated at 17. So there is no age.
But how much time, when you meet with your lawyer and you say, okay, we want a conservatorship, is it going to be a 2-year process that if you don't start it and do it not
going to be in the
18?
next 2 slides of process.
Okay.
But it depends on which route you go. So I can just briefly say, if you represent yourself, sometimes some parents are very savvy and can fill out all the forms or a lot of forms, a lot of checkboxes. It gets kind of confusing. And if you've never seen them, if you keep messing up, then the court's going to keep pushing out the date until you fix everything. And we've had parents report that it's taken them 1.5 years because they just always mess up a form or are missing something or need some specific form that they can fill off. But I would say the quickest, and the most effective would be maybe 2 months. And 2 months is like you are on top of it. Everything's been crossed, dotted, and there isn't anything missing. Any other questions? Okay. So a limited conservatorship is less restrictive than a general, and it has certain powers. And I just want to clarify that a limited conservatorship with the 7 powers does not translate to a general conservatorship. So someone can have a limited conservatorship with all 7 powers, and that doesn't mean general. So general usually carries the presumption that someone is incompetent, does not have any decision-making ability, whereas with a limited, they have some decision-making ability, but might need support in certain areas. Some of those areas are to fix residence, to choose where someone lives, make educational decisions, and then when someone becomes 22, that translates to day programs, determine social and sexual contacts, who they interact with, their friendships, what kind of relationships they may solicit or engage in, who to marry, and then medical treatment, contracts, and then access confidential records. So for example, if you have a confidential records power, you wouldn't need a release. That would be superfluous. So you could automatically, just with that power, access records or contact various professionals to obtain information. So when you petition for certain powers, you may get all of them, you may get some of them, or you just may not get any. Sometimes a parent might petition for conservatorship. I was in court on Tuesday where a parent petitioned for a general conservatorship about 3 months ago, and the hearing was on Tuesday, and then she ended up dropping the whole thing because she didn't think that it was necessary anymore, given a bunch of different changes in circumstances. So sometimes the court may decide, or sometimes someone might drop out at the last minute, but sometimes if it's not appropriate, or if the court thinks that it's too restrictive, for example, they might limit certain powers. So, and Tuesday when I was in court, there was another case where a family applied for 7 powers, and they only ended up getting 5. So it depends. And then all other rights are retained that are not mentioned above. So if someone has 3 powers, then to everything else they maintain themselves or retain themselves. All right, if you go to the next slide, limited conservatorship finds that an individual lacks capacity to perform some, but not all tasks needed to personally or properly provide for clothing, food, shelter. And then clients' wishes should be respected to the greatest extent possible. So you're supposed to, at least in a limited conservatorship, try to gain whatever, or understand or discern what a client wants to the greatest extent possible, and then try to make decisions based on whatever those wishes are. And then the other thing is that it's only used as necessary. So for every power, there has to be some evidence to show why it's needed, based on whatever limitations or evidence or information you may have. And with limited conservatorships, finally, there is a requirement in the law that it's used to encourage and promote the client to have the most independent, typical, and productive life. And sometimes I've seen courts review a conservatorship after it's been established and say, you've had 2 years, but the client's not in a day program, they're not accessing any services, and you're not meeting this requirement. And so, come in and explain what's happening. So sometimes that's what that would translate to in at least practical terms.
So the court can take the conservatorship away at that point?
Yeah, so as soon as conservatorships get terminated, or conservators can be removed or suspended, but every year after conservatorship is established, or after the first year, it's reviewed every 2 years. And a court investigator goes out to the home, interviews different people in the client's life, talks to the Alta social worker or service coordinator, and then sometimes based on that information, once the judge reads it, if everything's going well, then he or she will say the conservatorship is going well, it should continue. In other cases, he or she might say, oh, I think there are some problems, I'd like everyone to come, or send out an order to appear in court at a certain date and explain what the issues are, or provide some written response. So when we think of general conservatorship, we usually think about someone with severe or profound intellectual disability or severe mental health issues, for example, dementia. Typical characteristics of someone with a general conservatorship is they're unable to express desires or are considered incompetent in a criminal proceeding. Clients that we usually see with general conservatorships that come across our desks now usually are nonverbal, they can't make any decision, they don't usually respond appropriately to questions, so if you ask them, do you want to eat chicken or beef for dinner tonight, they're just not going to answer anything, or will tell you peanut butter. Arsenized peanut butter, that might be appropriate, so they'll say the sun. So it usually is just not related to the question at all, and that's what it may mean. So it's someone that really doesn't have that kind of decision-making ability, won't respond to questions, and needs support, and that support will always be lifelong. Whereas, for example, sometimes we see clients that are at 18, that by the time they reach like 28, 30, they have grown exponentially, they've learned a lot more skills, their level of functioning has increased, and they may not need that much support. But usually with a general conservatorship, there's somewhat of the implication that this person needs that support, and it's going to be lifelong. If you go to the next slide. With the general conservatorship, you still have the right to receive visitors, which is kind of ironic because it shows to some extent that it's kind of designed for the elderly, because sometimes conservatorships might cause some strain in family relations. So with a general conservatorship for someone that's elderly, obviously like grandkids might want to see grandma, or like cousins might want to see grandpa, and that's what it's intended to be for, to receive visitors, not to have to take someone out or go somewhere else. Whereas with limited conservatorship, you don't have this right, and if someone has the social and sexual contacts power, they can actually decide if you receive visitors at all. So there's kind of a distinction there, if that makes sense. And then telephone calls, personal mail, and then also the right to vote, marry, unless restricted by a court, and in most cases those two are restricted by a court for a general conservatorship, because that person doesn't have any decision-making ability, they're not going to necessarily be able to marry. All right. With both of the limited and general conservatorship, you maintain certain rights. So when someone gets a conservatorship, they have to sign an agreement or a handbook, and it says that it spells out that whenever, irrespective of if you have conservatorships, a client still deserves to be treated with understanding and respect, make or change their will, contest the conservatorship, terminate the conservatorship or request that it be terminated. If they have any problems, to request that they be represented by an attorney, and then ask questions or express complaints about a conservatorship, and then also control and allowance. So we have some clients with jobs or get some form of income through their day program, and a conservatorship does not cover that. So they can always retain that income. Any questions? Alrighty. An LPS conservatorship, just briefly, it's someone who's gravely disabled in Sacramento County. The county usually initiates these conservatorships because they are quite restrictive, and it's quite heavy duty. And then every year it has to be renewed, or you have to show why it's still required, otherwise it terminates, which is kind of illustrative of the level of restrictiveness. And then next one. So to obtain conservatorship, let me actually go through this. Okay. So to obtain conservatorship, first you have to file documents with the court. And I know, I think we briefly talked about this earlier, but there are several ways, at least in Sacramento County. Does anyone else not live in Sacramento County? Here. Placer, Yolo, El Dorado? Okay. So in Sacramento County, you can either use a legal document assistance service, which is pretty much someone that helps you fill out all the forms. Usually it's just a few $100s, but they're not going to come to court with you. And in most cases, they're not going to help you afterwards. So if the judge says, oh, there's a mistake on the petition or on some of the documents, can you look over that and fix it? If some document assistance might not help you with that or tell you how to fix it, and then you're kind of on your own. So it's kind of sometimes effective, and then also it can be very quick and it's relatively inexpensive. The second option is, and it's actually quite recent, Sacramento County is offering to start helping people with limited conservatorship petitions. So you can schedule an appointment online now, and you can get free assistance with the conservatorship petition, limited conservatorship. And I think it's starting either July 1st or July 15th, I want to say. And we work with them, and we've been working with them to develop some of the materials and kind of go over the powers of limited conservatorship to help people decide whether power they might need or if they need a conservatorship at all. That is also inexpensive, but that just came out, or that's about to come out in a few weeks. But other counties, for example, have always had that service. So like Placer and Yolo offer that service, but in Sacramento it was usually you either do it yourself, which I haven't mentioned yet, or you do it yourself because of the forms and sometimes the confusion surrounding the whole court process. It might take a while. Or you can retain an attorney, and there is a list. Attorneys, I'd say, go anywhere from like $2,000 to $5,000. It depends on how much time it takes, and then also how many steps or how many hearings there are. So we'll talk about that at the end. But from the time you file the documents, then you send copies to family members, and then the regional center gets a copy. And then the court investigator or investigator from the court will go out and talk to various people in the client's life, conduct interviews, file some report. And then if it's a limited conservatorship, the court appoints the client an attorney, and then that attorney is supposed to go meet with the client and then figure out what they want and then represents them, and they represent them for free. So sometimes families might not have an attorney, but the client always gets an attorney in limited conservatorship. And then the regional center and limited conservatorships is required to file a report. So we'll try to decide whether or not, or we'll try to make determinations about whether or not it's appropriate. If you file, for example, for a general, if a general is appropriate, or maybe a limited may be more appropriate, and then which powers, for example, would be more appropriate in that situation. And then court hearing or hearings. So in Sacramento, most of the time, there's at least 2 hearings for conservatorship. But for example, if family members may object to the hearing or may object to the conservatorship, or sometimes parents may, or divorced parents might argue about who's going to be conservator, hearings can go on for a year, 2 years, it can go to trial, and it can be quite lengthy. So it depends. And then, for example, if the regional center says, limited conservatorship with only certain powers is more appropriate, then it might get continued a few more times for responses, or someone wants to go back and forth about it. So that's why there's hearings, because sometimes it can be anywhere from 60 days to like 2 years. Actually, the longest I've seen is 3 years. And then if it's granted, the court or the judge signs an order, and then letters of conservatorship are issued. And letters of conservatorship are the official document that show, like, this is a conservatorship, I have a conservatorship, and you can take it to the doctor, the regional center, and so on and so forth. But if some people seek conservatorship for a client that's 17, the judge would just sign the order, and it's not, you don't get letters until the client's 18, so you have to come back, and then you get letters. So at the top of every order, it says not effective until letters have been issued. Yes. Any questions? Yes.
You mentioned that family members can object. What's the legal age of a family member, and is it, what level? Is it like immediate siblings, or is it like aunt, uncle kind of a deal?
So technically the law actually just says any interested person. So anyone can pretty much come to a hearing and say, I don't agree with this person, or I don't think this person should be a conservator. And then usually at least a court investigator will have interviewed them, or the client's attorney will have interviewed them and then kind of assess the merits or whatever they're saying. But by law, you are required to serve the petition and the notice to all second-degree relatives. So most relatives, I think that's grandparents, kids, and siblings, I want to say, and maybe aunts and uncles, I would have to double check, but they all get copies of the notice and the petition. So they would see it, and then they all, it says the time and then the hearing, the location, so they could potentially come to a hearing. But the law just says any interested person, and interested is pretty vague. Yeah. Any other questions? Yeah.
So I have some concerns for my son with like undue influence and finances, especially once my husband and I aren't around. And he may be, he's higher functioning, so I don't know of the 7 powers, even if we got a conservatorship, what we would get. So in terms of like financial protections, it seems like the special needs trust is really just to protect his benefits, but it doesn't, I mean, he could still be, is that going to protect him a little, or is the financial power of attorney, or the
no, so
limited?
I would say if you are worried, for example, about money going or being taken or used, the best solution, I would say, at least in my opinion, is a special needs trust, because there is some oversight, and a lot of special needs trusts can also be court supervised. So at least the court is watching and then seeing how it's dispersed. So I know a case we had a few months ago where parents passed away and a client had a special needs trust, and the person that was managing it was another relative, and he wasn't giving the client any money, even though it was his. So all we have to do is just let the court know, like, hey, this is happening, it looks like there's an issue, and the court ordered him to disperse it. So that would be more helpful. At least
Okay, whether or not he has conservatorship, the special needs trust can kind of be another level of control.
And usually to set it up, you talk to an attorney, so that would also be helpful. You can discuss all of those and we can get some advice.
It seems like the special needs trust has a lot more people looking into than.
And you could set up like a successor trustee, you can put in multiple people, also with a special needs trust. You can have an advisory committee, or you can have multiple people that make the decisions, or you have to require that they consult with certain people. So that's why I would say it's more helpful.
And did you have the special needs trust people on your list of resources? You said you had some references, or is that something to email you with?
It's not on this list, but if you take my card, I can send you their names.
Okay.
Yeah. Any other questions? Yes.
Can more than one person, besides mom and dad and or just mom or just dad, be part of that conservatorship? So many things are going on in life. I know you hear that mom's here and then all of a sudden mom dies tomorrow. So like to kind of have like that beneficiary trustee kind of a backup plan.
Yeah.
Does a conservatorship have that same process?
So when you get a conservatorship, you can also be co-conservators. So we've seen conservatorships with like 4 people that are conservators. I've also seen one with just 1 person. So you can do that. And then, for example, if a person passes away, then new letters would be issued with just those 3 people's names on them. And usually, sometimes, or some petitions will say like, John is going to be the primary conservator, and then for any other secondary issues, you can contact, Jane, conservator, and she could also do that too. There is also one difference with limited conservatorship. So if a conservator passes away, by operation of law, it's automatically terminated. And by operation of law just means that there's no hearing or anything. It just happens automatically. Whereas with a general conservatorship, if the conservator passes away, there's still considered a vacancy in the office of conservator, which means that the court has to have a hearing on it and then decide if there's any other family member that's willing to serve or anyone else, like the county, the state, or whether even conservatorship is needed. So I know maybe a few months ago we had some cases where several conservators learned that they passed away, they were general conservatorships, and in a few of them the court terminated them, and then a few of them a family member stepped up, so it depends. Any questions? All right, so the regional center review process, it goes like this. So once you file for conservatorship, you are required to serve the regional center with a copy of the petition. And then they will take that petition and it'll be forwarded to the service coordinator or the social worker, and they will go and interview the client, the conservator, or the person that wants to be conservator, or whoever they are. And then they'll also interview any like teachers, for example, or anyone else that's really involved in the client's life. So for example, a vendor, a day program, and ask them questions about it. And then they'll bring all of that information, and there's a multidisciplinary team review, which at Alta, for example, happens every Thursday. And I lead that committee, or that review team. So today we had reviews that started at 8:20 a.m. and then we ended almost by noon. We had like 8 or 9 cases that came up for review. So we'll discuss each case, go over all the information that the service coordinator has gathered, review any other documents in the chart or in the file, and then come up with some recommendations. And then based on whatever those recommendations are, we file them with the court and then provide copies of whatever those recommendations are. And then usually, in most cases, I appear at the hearing in most of our counties, actually all of our counties. And then there's usually ongoing informal monitoring of conservatorship. So we do have some cases, for example, where a conservator might not be making very good decisions or might not be acting in the highest best interests. And sometimes we can inform the court investigator's office or the court and request some kind of action be taken, like a review hearing. All right. Well, thank you, everybody. Let me know if you have any questions. I'm going to hang around for a little bit. And thank you.
Thank you.